fall day in New York. I hope everybody is safe and well. Again, we have a really fantastic conversation all about IP with TED Sabety. So we'll go ahead and get started. I just have a few quick thank yous. A little bit about New York Tech Alliance. My name is Andy Saldana. I'm the Executive Director of New York Tech Alliance. We're a nonprofit organization based here in New York City, really driving access, equity, and inclusion to the New York Tech ecosystem through events, programs, and always promoting new technology. So please feel free to check us out and learn more about nytech.org. Again, quick privacy statement, we are recording this, so if you're not comfortable being on camera or having your audio captured, please make sure your video and you're muted and that your video camera is off. Quickly, again, a few quick thank yous and announcement, code of conduct, introduction, and then the discussion. First, a few quick thank yous to all of our amazing annual partners that make the work that we do possible. Everybody, including Sabety and Associates, to Eisner Amper, Crown Castle, Xander, Propeller Industries, and many, many more. We encourage you to check them out on our website at nytech.org/partners. And then if you like what we do and want to help support the New York Tech Alliance community, we encourage you to make a small donation when you register for one of our virtual events. Become an individual or supporting partner of New York Tech Alliance, or simply make a small donation on our website. All of that really helps us continue the work that we do and create the content and the events to bring the community together. And we appreciate everybody's support in that. And I lost my slides. Zoom does that from time to time. So strange. Code of conduct. Just again, we're going to open it up for Q&A. Just be respectful, and then we ask that you be present for the conversation. We encourage the conversation, so if there's a question that you have, put it in the chat. I'll make sure to monitor that and get your questions asked and answered. And then a quick disclaimer, we are talking about very different IP issues. This is in no way intended to be legal advice, and quick disclaimer, make sure you read it and understand that this is just for content purposes. And then that brings us to today's conversation. I'm really excited. Ted is a really phenomenal member of the New York Tech community. I was introduced to him a couple of years ago and just really hit it off with him. He's not only a great person, but a fantastic lawyer. He's helped us with some of our copyright and IP issues, and has just been a good friend. So I'm really excited to welcome Ted to the event today, and we're going to learn about him, specifically about his firm, and then get into a great conversation about IP and what founders need to know when they're navigating intellectual property, when they're navigating copyright issues. And so Ted, I'm just going to hand it over to you, stop talking, and let you take it away.
Great. Well, thank you, Andy. Thank you for the opportunity to speak and share with everybody who's joined us. So my background is that before I was an attorney, I actually worked in the technology space. It's one of the advantages that our practice provides to clients. That I used to do chip design work for Hewlett-Packard, and ended up doing computer architecture research at Columbia University, where I was involved in the earliest parallel computer processing architectures being experimented with in the mid-1980s under the Strategic Defense Initiative in the Reagan administration, as it turned out. And so I also ended up, it's sort of how this happened is a whole story, but I ended up in the music business. So I've had a lot of content experience as well, involved in IP, and then sort of tied it all together by getting a law degree and concentrating in the area of intellectual property, of course. So one of the things that we work with when we work with clients is we work with having domain expertise over the stuff that they're involved in. So for example, because I was involved in artificial intelligence work, which is what the parallel computer architectures were for in the 1980s, working with companies even now, they're doing AI related applications. We understand what we're doing, what they're doing. There's not this huge learning curve between the inventor or the company's technology team and us over what it is that they're up to. So we've been involved in AI, we've been involved in cryptocurrencies, we've been involved in various kinds of encryption technologies for document security and other kinds of protocols for establishing security between computing systems. We've been involved in trademark aspects as well, especially on the internet, branding. We've been involved in copyright issues, both involved in things involving music, of course, but also involving software copyrights and things of that nature. In fact, one article I wrote while in law school on computer software copyright was cited by Microsoft in their brief in a lawsuit between them and Sun Microsystems over the Java computer language, because my paper was about whether or not a computer language itself could be copyrighted. So we've been involved with these different aspects for quite a while, and I think one of the reasons why the practice has done well is that we have an ongoing dialogue with our clients as they develop their businesses and projects, and even their additional projects that they do. So, that's kind of in a nutshell my relevant background. You can find more about it on our website, www.sabety.net. But so that's the. I don't know if that's. Is there any more? If there's more stuff you need to know at this stage, then Andy, proceed.
Yeah, no, I think that was a really great self-introduction and much better than I could have ever done. All I know is that I really love talking to you every time we get on the phone or we connect via Zoom. We just have these amazing conversations. I call you about one topic or one particular issue that we're encountering, and we spend hours on the phone. You're just so full of amazing knowledge and experience that it just makes it easy to digest some of these legal issues that we encounter as we grow businesses and such. So I hope everybody gets to see that side of you today during the conversation. But one of the reasons that I asked you to participate in this type of conversation is that IP, copyright, intellectual property, all those things that need to be protected as a business owner, as a founder, is so sometimes arduous to navigate and just oppressive to even figure out where to start or where to begin. So to start the conversation, I think we should just follow that part and kind of, I would love to hear, like, how do you get started as a founder? What issues should you be focusing on when you're first starting a company, and kind of at what point do you start thinking about intellectual property protection and copyright?
Well, that's a really good question. I think that what I can do is answer that very succinctly in saying that one should start a conversation with an IP lawyer relatively early, which is one of the reasons why we run a boutique, because a lot of our clients have been startups. In fact, one of our clients was a NITEC participant way back when. That was ShopKeep, and we helped them develop their IP. And last year they got bought out by Lightspeed for $440 million.
Oh,
so
awesome.
there's a NITEC alum right there that's that we've worked with for many years. But I started working with their founder when it was just him and his wife in a room downtown. So the reason why you want to start at least getting a conversation early, it's not necessarily spending a lot of money, it's really getting a conversation early, is to see how the different aspects of intellectual property law interact with what the business strategy is going to be and what the business model is. So that's one thing that I do recommend. I mean, it's worth, a bit of time with an attorney to get them started, or you can get the entrepreneur starting to think a little bit about that. Is this a branding play? What's my brand going to be? Is this going to be a licensing play? Is this going to be a distributed product or service? So then you also have the next thing that founders have to immediately think about is when they start getting the code developed. I mean, here it sounds like I'm focusing really kind of in on technology and presumably computer code, but once you start getting the code is getting developed, you immediately have to be considering the IP issues, because if you have an outside contractor writing the code, if you don't have the right kind of contract provisions in your contract with them, they end up owning the code. In fact, we're doing, we have a dispute now on behalf of a client where the contract was, they decided to negotiate the contract themselves, and now they got into trouble because they paid the money, but they don't have the code. That it doesn't work. So, so you have, you know, but that's why that has to be considered to make sure that the company is owning what's going on. And then that's when you're doing these outside contracting relationships that a lot of companies do now. They don't really write the app. They hire a company to write the app for them. So right away, there's IP issues right there to make sure that the company is on top of what it is they're contracting to get done. As the company hires people, they have to make sure they've got everything straight. And then on top of that is when they start talking to potential customers or investors, you know, organizing what it is they're willing to say without a non-disclosure agreement, what it is they're not willing to say. So, you know, it really boils down to starting a dialogue, and not necessarily, oh, we're going to immediately file a patent, but it may be that that's relevant, but you only will know that when you start the conversation.
Yeah, and so, you know, you brought up some good points about especially outsourcing development of a tech product to an outside firm. And are there a few things that that founders can be aware of, or some common pitfalls that they might not notice in that kind of contracting language that they should be aware of?
Yes.
Or
there is, and one of the most important things is there are really a couple of things. One is it's very important, making sure that your company, it explicitly says that your company is that the contractor is actively assigning all the IP, copyright, patents, the whole bit in the code they're developing into your company, that they're maintaining confidence over everything, both the business plan, because they're going to be privy to the business plan in order to build the app. I'm using an app as an example.
mm-hmm.
And then this is really critical, and a lot of people miss this one, which is that even if the contractor builds the app, the reality is often the contractor ends up hosting the code through their GitHub account, or they are hosting the application on their server, or they actually initiate the account with, say, Amazon Web Services as an example. In fact, the customer is not in the loop on those, controlling those accounts. And so if the relationship goes sour for some reason, the customer that paid for everything actually doesn't have the passwords to the Amazon Web Services account, doesn't have physical control of the code. And you go down all these lists, so that all has to be thought through in the relationship, all those aspects as well. And that's something we do when we negotiate these for companies, is to make sure all of that is straight.
Yeah, that you just brought up many technical aspects of building an app that I think as a non-technical co-founder you often overlook and not think about where that code lives, where it's stored, how to access it. And that makes a lot of sense. So thank you for that. I think that that's a really great advice. You know, and you know, IP and copyright goes beyond just the technical product, right? So you know, when you're looking at starting a company, there's also the brand and the messaging and the content that you're creating. So how does that really impact the development of a business and the conversation around IP for a company?
That's a good question. In our view, it depends, Andy, on what the business strategy is. It goes back to starting the at least a conversation with the IP attorney early on to understand these ins and outs. So, you know, we have clients that are tech companies that have a particular narrow market, you know, very, very, very clear it's a technology thing, not going out to the general public in some sense. So they'll name their company something. The branding exercise there is isn't a big deal. If somebody comes along and says that's our brand, they'll change it because it's just a small company that's going to end up getting bought by somebody else because of their technology. Now compare that to another company that's building an app that's going to service. The idea is it's not advanced technology, so to speak. They're building out a service and are going to build up a clientele. They hope to have 500,000, 1 million users of their service. Now you have a branding question because you're going to spend a lot of money promoting that brand. And in brands, you do not establish ownership of your brand because you've got a URL. Just because you bought a URL from GoDaddy does not mean you have rights to use that brand. And that's a whole process that a brand has to be cleared by an IP attorney, typically is who you want to have do that, to make sure that if you're going to use that brand, you're not going to step on the toes of anybody else. Because one of the worst things for a company is they have to rebrand a company after they've spent $500,000 investing and promoting the brand to the public. I mean, it's almost, it happens. And that's something you have to be careful about. And so we recommend that a proper clearance get done of the brand. And this leads to another thing, which is there are services on the web that say, oh, well, we'll file a trademark for you for $150. They don't do a complete brand search. And so those services, when they're cheap, they're not giving you the full clearance. And that is something that ends up being a problem. And we've had clientele that we've worked with in litigations over trademarks they're using, or their senior trademark owner says you can't use that trademark, it belongs to us, and they thought that they could use the mark because they got a URL. Yeah, but we have it .com, we own the URL. That's not the way the law works. And so that is a place that I've seen a lot of startups run into trouble. So that's something you actually want to pay attention.
Yeah, and that hits on one of the other questions that I had for you about how does a startup even do that clearance, right? How do they check to see what's if they're infringing on somebody else's patent or copyright or whatnot?
Well, that's a good question, and that's can be an involved answer, but because there are 3 different things you've raised. So let's start with branding. Obviously, the first step to brand clearance is doing a Google search to see if anybody else is doing it using the brand. That's only the first step. After that, we get involved in starting to look at U.S. Patent and Trademark Office records. And then if a proposed brand clears that hurdle, then we get a more formal search, countrywide, typically database search, and we review that. And based on that, we can sort out who out there is using similar marks and things like that, because that's where it gets tricky, because it's a question of similarity, not exact, not whether the brand is exactly the same as the senior mark. If you're going to sell hamburgers and you're going to call your brand McDonald's with MKDONALDS, you're still going to get sued and lose, right? So the string matching is not going to do it. So it's that's that particular process. In the patent sphere, it's its own sort of complex area. We do prior art.
Sorry about that.
So in the in the patent search area, we can look at prior art to understand whether or not what you do is so far in the prior art that no one owns a patent on it, or in other aspects, it's sort of that's a different cost benefit analysis there. And in the copyright area, it's different too, because copyright infringement involves access. So if you have no access to somebody's work, just the fact there's some similarities to it doesn't mean there's infringement. So there are different aspects of all 3. I would say branding is the one that becomes the most troublesome for a startup that's going to be customer facing, because often the technology they use isn't necessarily that advanced. It's, they're running an app. It's really all about particular service niche that they're filling. So it's a branding exercise. But in higher tech stuff, there's a whole nother aspect of this. So each one of those intellectual property law regimes has its own sort of clearance process if you're looking to clear. But some clearances can be very expensive. So there's a cost benefit analysis that has to be conducted first and discussed to see whether it's even worthwhile doing it. So It's a very case by case specific thing, but I would say branding is the one that we talked about and is typical for an app type project. Although again, as I said, it depends on the specific technology.
Yeah, absolutely. A question came in from Victor Lee regarding like how deeply do you need to protect brands for specifically a consumer product, but I think it goes for any brand that's creating multiple versions or sub brands underneath the larger brand. And his product is, for example, Pepsi owns Slice, which comes in a variety of flavors like Amazing Orange. Do they all need legal protection? Like how deep does that go?
That's a good question. It's really a cost benefit analysis. It depends on the particular situation. You want to have obviously the main brand on the package, if you will, if we're using Pepsi Slice, to have very clear protection registrations. Pepsi's Pepsi. I'm sure Pepsi has, Pepsi has, they own the brand and registered in most countries around the world, presumably. Slice, which appears underneath Pepsi, they probably have a trademark registration, probably a logo registration as well. And then you might say, well, what about, it's the Amazing Slice. Do they get a trademark over Amazing? That requires a discussion of how likely is it that your competitor is going to come out, with their own soda and call it Amazing. If they call it Amazing Slice, they get sued. If they call it, amazing tangerine, it depends on the presentation, because here's the thing, you don't necessarily need a trademark registration to sue for trademark infringement. So having the registration is what establishes dominion and control over the brand in a way that's different than an unregistered mark. And there's certain litigation advantages that you want to have, and it is looked at in a sense as an asset. So what I'm getting at is you don't have to go all the way down the rabbit hole of how many sub-brands. Every sub-brand I have has to have a federal registration. I don't think you really necessarily need that. It really depends on, in a particular case, let's say you have a sub-brand, but you're looking at that, expanding that niche product, and you think that over a 5-year period, that's going to become the flagship. Maybe you should clear that and get a registration over it, because the unregistered marks have certain limitations in how you assert them as compared to the registered mark. So it really is case dependent, but you don't have to have a registration, because here's the key thing a lot of people misunderstand. The U.S. Patent and Trademark Office doesn't give you a license to use your trademark. You don't have to go and ask for permission from the U.S. government to use a brand. You can use whatever brand you want so long as somebody doesn't tell you in court to stop. What the registrations do over trademark is give you advantages in the world of trademark law around the country and around the world, for that matter, that make it easy for you to prevent your competitor from using your trademark. So that's where the registrations come in. So it's not, oh, I need to get permission from the US government to build this little sub-brand and add, this little sub-brand onto my product. No, you just want to make sure that there's somebody isn't going to come along and say, you need to take that off your package. And believe me, once you've already have the package in the market, that gets expensive. Okay. Yeah. Sending out people to put little stickers on your soda cans everywhere your soda can appears, Pepsi doesn't let that happen. They've got clearances for every brand that appears on their cans, right? So as I said, it's a cost benefit analysis. If you're a itty bitty tech company with a website and we have 5 customers that use our advanced technology and we call ourselves IBM, IBM comes along, says, change your name. You go, okay. You flip the website to, I don't know, ABC, and you're done, right? Those companies, when you see that, branding isn't a big issue for them because their customers are like 5 customers. They don't care. They email their customers that we changed our name. Okay, whatever, right. Ted. Right. But if you're going to really be out there with a customer service or product, it's the flip side of that. It's really expensive to change your brand.
Well, that brings me to another question of, when you're building a company, you're moving fast, you're trying to scale pretty quickly. You're worried about the business model, the revenue model, obtaining customers. And so the branding and marketing side is moving in tandem. And sometimes you don't pause to think about like, when do I need to make this happen, and how long will it take? So I guess my question is like, it sounds like it's something that should be, you mentioned, having conversations with the lawyer pretty early on, just so you have these ideas of when things should happen and how having that resource available. But, for a founder, what does that process really look like? And when is it taking way too long, right? Like how can you tell if a lawyer is not doing a good job, and providing the best service for you, I guess. And
That's an interesting question. How do you know when your lawyer is not providing a good service to you on this particular topic? Well, that's a tough question. I mean, if they're okay, so let's talk about how long does it take. Now, the typical brand clearance shouldn't take that long, and it's a question of how it's organized. So I think if your lawyer is not experienced at doing this, in terms of helping you organize the brand determination process, it should happen early on. So as you're considering what should our brand be, right away there should be IP counsel involved, because here's what happens. Sometimes companies hire a marketing consultant. So the marketing consultant may not be well versed in IP. So the marketing consultant says, here's the brand we're going to use. Done. Let's get started. So they're already starting to contract with people to I don't know, let's say it's a package to print the box and everything. No. You have to get it cleared before you spend that kind of money. So now what happens is, in the normal process, somebody sends us a brand, and we early on, they've already done some Google searching and said, nobody seems to be using it. We got the URL. Okay. So then we go to the next step and we start looking at it. Usually that should be turned around in a matter of, a few days. And then if we go to the next step and get a full clearance, that should only take a few days as well. So frankly, clearing a mark shouldn't take longer than, a couple of weeks, or clearing it or declaring it dead. I mean, it's one or the other. Clearing it, not every mark gets cleared. So what we do is we try as early on, find out whether it's likely to be a problem, and tell you to stop, we're going to stop here, not spend any money. Let's go on to the next candidate. So what I'm getting at, speaking of candidate marks, is when you're brainstorming your mark, don't fall in love with one mark. Think about, all right, this is our first choice, this is our second choice, this is our third choice, and now we're able to quickly go through and say, first choice, that's going to be hard to clear. We're not going to get a registration. This is a branding play, this business. We need a registration, so that's out. Candidate 2, that looks clear. We probably should be able to get a registration. We'll move forward with that. So, and then we'll get the formal clearance and get that to you within, a few days. And now, then you push the button on having your artwork generated and things of that nature. So that's, if it's starting to take like a month or two, or your lawyer isn't even addressing the question, that's an issue. Like if people are already talking about, let's get the artist to start making the logo with that word in it, and no one's cleared the word, that's a mistake.
Yeah, absolutely. Okay, that's great. That's great insight.
Interrupt, Andy. On that, you need to get clearance for your logo also, by the way, right? So if you come out with a new soda whose script is reminiscent of Coca-Cola, but it's not Coca-Cola, that can actually be a problem, believe it or not. So,
Yeah, all really, really fantastic insights. And, I wanted to shift the conversation a little bit. We've been talking about branding. We talked a little bit about code and deeper technology, and I want to get back to that part of the conversation. And so, as a tech organization, we see a lot of companies creating new technology, new types of technology, some of it super innovative, some of it being built on existing technology. And my brain is going in 3 different directions right now, but I'm going to really focus on some of the startups that are innovating and creating new types of technology. And so it's hard, like comparable to brands. How do you know that what you're creating is new technology, and how do you start protecting it as early as possible?
Those are two questions. Those are two different questions. Let's start the second question first, because that's where a lot of people make a mistake. Before they talk to their IP lawyer, they publish a white paper describing their fancy new technology. That white paper on your website could be considered prior art to any future patent application that you might seek to file. So generally speaking, you need to talk to your IP attorney before you publish the white paper, before you offer your product or service that relies on this advanced technology to the public, okay? Before you put it into use that way, public use, you need to get the protection figured out. So normally what we do is when we're talking to our clients that are developing new kinds of technology, and we have clients involved, as I said, in artificial intelligence processes of one kind or another. You know, we are in the conversation, and before they move forward with a particular step of publicizing or offering the product for sale, we go down the list, making sure that we have patent applications filed on the things, the innovations that they feel are of particular importance that has been done. We've got the filing date before they go out with the white paper or publishing the article or offering the product or service for sale. So that's very important for advanced technologies. On the question of, well, how do they know whether it's new? That's a deeper question. So generally our experience is in the most advanced areas of technology, the people that know whether it's new or not are the advanced scientists and engineers that we work with that are in the fields. So for example, there's a friend of mine who's been a longtime client. He's a professor of computer science and at a major university. And we've gotten several patents for him for a company he ultimately sold. When he was doing this, it's in the field of advanced databases and the relationship between relational databases and AI lists. I forget the names of the data structure off the top of my head. It was the tuples not for SQL, the other language. Pardon me, but anyway, so in that particular case, Dan was at the cutting edge. It was his field. I mean, we could have done a prior art search, but the reality was he knew.
He knew,
I mean,
right?
He was the man, right? So there's no one who's going to tell him what he was doing was in the prior art. He knew what was in the art. He knew what he was doing was different. And so, he got several patents. So typically that often happens. The gray area is when you're not sure, it is possible we do prior art searches where we look for stuff, but in the prior art world, searching for prior art can sometimes, it's again, a cost benefit analysis. You could spend lots and lots and lots of money looking for that needle in a haystack where this particular algorithm was described by a Russian PhD student in the University of Moscow in 1992, working for the Supreme Soviet Technology, Yeah, and those prior art searches, that happens when Microsoft is suing Google or vice versa. They'll spend that kind of money. Startups not going to spend that kind of money. So we look at the cost benefit analysis of the prior art question, or is there an existing patent we should be concerned about? We look at that in a case-by-case basis, and there's really no hard and fast rule on how do you deal with that particular situation. But it's a philosophical question. But usually the technologists that are really at the advanced cutting edge, they know who's doing what. They know the different researchers working on what aspects and why what they're doing is different. They often know.
Yeah. Exactly, and I imagine that could be a whole conversation around building tech within an academic setting and how to protect like what part belongs to the university versus what part belongs to the inventor. I've had that conversation.
That's a very interesting question. We have a client now that is a university professor who's developing with somebody outside the university a particular app. I can't get into it in detail, but and there it's a question of what are the university policies for the professor. And if they have an employment contract, you have to look at that and how that works. There are various mechanisms that professors have used in the past to establish that. We've negotiated licenses with universities, with MIT, for example, over getting technology into a startup. And so there are various things that go into that process. But that's very important. And it interacts with your government funding contracts. We've been involved with that as well, because there was a statute passed called the Bayh-Dole Act back in the 1980s that made it possible for universities to own the product, own the IP and the product of their research. And that's where most universities end up owning stuff. But that aspect and how that funding agreement works and how your processes work under that specific funding agreement, if it's only part of what your project is doing, gets to be very critical in terms of how you work that. And so there are no hard and fast rules on that, other than to be aware of that, in terms of how you get funding from the government. For example, you get SB, the Small Business Administration grant, for example, you're going to have these kinds of provisions in there that have to be considered.
Yeah, absolutely. We could probably spend an entire hour and a half just focusing on that piece. But a lot of our audience is early stage founders and early stage entrepreneurs. The next question I had, we talked about new technology, but I see a lot of companies building on existing technology or using third-party applications to build a new product or a new service that is filling a specific niche. And so they're not using their unique code base. They're building on top of existing code bases, or using open source, or that I'm sure that's a whole nother conversation. But for some of our founders, it would be great to understand kind of things to watch out for, or things to look at in service agreements or whatnot, to make sure that as a founder, you're protected as you build your company forward.
That's a big issue these days for two reasons. First, building what you can buy is, in the technology world, is often considered a mistake. As the old rule is, don't build what you can buy. In the electronics world, that was always the case, and it's the same in software. It's like, why am I going to build a new database? I'm just going to bring in some open source piece of code. And so I understand that fast code development relies on just pulling in whatever modules that are already out there that work. So there's a little piece of advice is, if you're doing that and your developers are doing that, you need to make a rule, and you need to put this into your contracts, that any third-party code that's going into the code base is getting documented, that that you went out and at this website they offered up this piece of code and this is where that module came from. And then if they have a README file that contains their particular open source license, that open source license is stored somewhere. Because what happens down the road is, when you get your first round, your Series A financing, the investors are going to ask, does your code rely on open source software? You have to answer yes, and then that becomes a due diligence issue. Do you have all the which open source licenses are you using? So now you're going to have all those open source licenses. If you haven't done that, and you come to your Series A financing, it's going to slow it way the heck down, because that's going to have to get cleared up to make sure, if you're the Series A investor, I want to make sure they've got the proper licenses in place for the third-party code that they're using. And so that's probably one of the pieces of big general rule advice I can give, which is keep track of the open source that's inside your product. The other is the business model. If the business model is going to be doing site licensed code, so you're not going to be a cloud-based service, you're actually going to have a piece of code that goes out and is acquired, and when I say acquired, physically brought in, running on the servers of your customer, and they're Fortune 500 companies, they're going to ask you to make a representation that there's no open source code in there. So that the question of using open source code goes all the way back to the business model question. So that's why I said you need to talk to an experienced IP attorney who's done this kind of stuff at the outset, because that question should come up early on. You know, are we going to use open source? Well, I don't know. We're going to be licensing Fortune 500 companies to actually download and install our code on their server. Well, hey, maybe you don't want to be doing open source code at that point, because they're not going to accept that, except in certain circumstances. So that gets to be another conversation that you need to have to think about as, you know, how does the business model interact with your licensing model? We've done lots of licensing and we work on this stuff. So that's a part of the conversation you need to have. So I don't know if that answered the question, Andy, but.
It does answer the question. And, you know, a lot of tech companies also provide create an API or an SDK to provide their technology to become that third party technology. And so it also goes, that insight also goes into building what those agreements look like as you start to license it out and create a customer and revenue stream from that side of the business. I imagine as you're building, you're looking at what you're using, and then as you're producing and then licensing out, you also have to look at that side of the business in kind of a similar fashion.
Yes, I mean, there are cases the customer is okay with certain kinds of open source licenses. It's just that's why you need to keep track. That's the main number one thing. If you're going to rely on open source code components, you're keeping track in detail, because what happens in some of the negotiations is the IT department at the Fortune 500 company really loves your product, so they're going to tell their in-house counsel who's, you know, unhappy it has their Hornbook rule number one, no open source. Wait a minute, let's have a look at which open source you're using. So it turns out you're using, I don't know, something that's everybody uses, you know, and it's generally nobody's sued over it. It's like well-known piece of code. Okay, so you have to have a list, except for what's listed in Exhibit A. We don't have any other open source code. So that if you can get to that point, you're winning the negotiation on this issue. And then the IT department signs off on it, but the customer says, these are all fine. We don't care. There's we don't see a risk there. Then that's how they get, that goes back to why you need to keep track. That's the main thing. Keeping track of your open, so you know where that open source came from. You're telling everybody you cannot insert any open source into the source code tree unless it's been cleared by us. That's the other thing. Sometimes the open source license is not particularly friendly. That's why before you rely on the code, you have to look at the open source license.
Yeah, absolutely. Great. I'm going to pause there and let the audience know that if you have any questions, additional questions for Ted or myself, please put them in the chat and we'll get them asked and answered. And, you know, the conversation has been really interesting to this point, and I'm learning a lot about what to look for and what, you know, things to be aware of. And while we're waiting for the audience to come back with any questions, I would love to hear why a boutique firm. Like, why did you start a boutique firm, and kind of what benefits does that provide to a founder who's looking for?
That's a good question. I get asked that because, you know, every once in a while, very often lately, large firms call up asking whether I join their big firm IP shop. You know, when I was at Paul Weiss, that was during the initial internet craze. And so Paul Weiss is a big white shoe law firm, very expensive. And right off the bat, I noticed that people I knew in the field doing the exciting stuff, just, you know, they were experienced business people. You know, some of them came out of consulting world and out of the software world. They just weren't going to hire Paul Weiss. They laughed at the rates, frankly. And they didn't see the need for a big law firm like that for what they were up to. And so, and I kind of noticed that the big infrastructure at a big law firm, huge capital costs. I mean, big law firms owned their own machine rooms at the time. This is like 2000, 2009. What did Paul Weiss own a whole server farm for? Are you kidding me? And so this is around the time of 9/11 as well. So there was a lot of upheaval in New York. And I just sort of decided that, you know, the cutting edge stuff that was happening in new media and technology was not coming to where I was working. Yes, I worked on the Napster case and the mp3.com, all the early copyright stuff on the internet I was involved with, did cut, sound recording licensing deals for EMI and Warner Music. But, that was about it. And that's, because they had a particular relationship with Paul Weiss. The reality was the new emerging companies that the people were starting weren't going there really. And even though the firm wanted to get into that. And so it just seemed like, the people I knew were looking for something more boutique to get their businesses up off the ground. And it sort of worked out that way. And so we've been doing it now for just about 20 years. My God, has it been? And so that's been, and we work with large law firms. I mean, don't get me wrong. We've been involved in mergers and acquisitions where, the company has been financed, and we are the IP counsel that, advises on the M&A deal or the investment deal or helping to negotiate the Series A investment. So we do work with large corporate firms, but, the boutique idea is that we have a dialogue that goes on between us and the founder and the technology people that grows over time and and that provides a certain advantage, not only because of our background, but also because having been there all along, we know we kind of have a coherent strategy, and we know what everything is doing. So the big firms, it's a little different. Like when you go to a big firm, they'll have a patent mill that'll crank up patent applications. But we had a client that they were like, we don't even understand what they're doing. We just end up paying the bill and they just work away at it. We have no idea what it is we're doing. And so I looked at what they were doing. I said, well, they're missing this particular patent claim doesn't cover your product. So we had to rearrange all that, because that, again, it goes to the dialogue between us and the founder or the key people in the organization that establishes that you're getting a proper strategy going forward. It's not, oh, we just need to have some law firm file some patent. It's like, no, it's got to be the right patent. And that's where the resources should go. So that's one of the reasons why the boutique, I think, is more effective for that kind of work. And so
Yeah,
we've been.
absolutely. And I really love that point about just getting to know the product and the technology, and, just the conversations that we have. You really go deep into understanding all of those aspects. So it's been really helpful for us in the past as well. One of the questions that came in from Alina asks, what are the most common mistakes you see tech entrepreneurs make?
Well, that's a really good question. I'll refer you to our website where I actually have a video that's titled, or at least subtitled, Avoiding the Pitfalls. We have a video on that of what the basic pitfalls are, but the most of, as I said, going out with a brand that hasn't been cleared when you're a business to consumer play, and formally cleared, not, oh, I bought the URL. So that's a big mistake. Going out with a software product where you run with a product offered for sale, you're a technology play, you didn't file patents on it first, because now you can't. So, there's, that's the second big mistake. The third big mistake is not attending to making sure that you have all the right IP assignments in place from your contractors and employees to make sure that the company is the owner of all this IP that's being generated by your development activities. I would say those are the big three.
Yeah, absolutely. And then once you, oops, I'm on your website and it made a noise. Once you are starting to create product and create technology and code, how do you stay aware of if somebody is infringing on your code base or using?
That's a really good question. So from the branding standpoint, what some clients do is they just have one of the Google services that's continually searching on their own brand, so you can see what pops up on the pages. There are services that we use that will actually go out and locate potential brand infringement and report it to us. That's the next level. On the copyright side, if your competitor comes out with something that's very highly similar to what you're doing from a product standpoint, you take a look at, there's various ways you can examine what they're doing, either examining their code, or sometimes what we've done is when it's downloaded code, we'll download their code. A consultant will install it and we'll actually do a bit for bit comparison. It's come to that. Then there's sometimes examining it from a patent standpoint, what the functionality of your competitors, what they're doing, and looking at how that kind of ties into your patent claims, and saying that kind of more likely than not, it's very likely. You can bring an infringement suit in patents without having 100% knowledge, because the extent what they're doing is behind on their server. You can't be considered filing a frivolous lawsuit if you can't get into their server to actually identify the infringement. But if you have enough evidence, and again, you have to talk to a lawyer about this, when do you have enough evidence to bring the suit, it is possible to do that. So, usually it's, keeping up with what your competitors are up to, because the whole purpose is to push your competitors off and not let them take advantage of the things you've innovated and then copy you to compete with you. And trying to grab your customers because they do the same as you do, but cheaply, but you're like, well, we invented this, So a lot of it is keeping up with what your competitors are up to is probably the best thing. I mean, it is possible in certain areas to do things like, copyright infringement detection by doing Google searches on an image. That is possible to do. But again, the reality is you all put this all together as it's a process of constantly monitoring what's going on out there. It becomes its own task that happens, So probably
Yeah,
the
absolutely.
best I can, in terms of one answer right there.
No, absolutely. And I could probably talk to you for another 2 hours just about seeing themes of technology arise within the industry, and similar products being developed at the same time, and how does that really impact patent and copyright. And then the other questions.
Andy,
Yeah,
that's a
go
great
ahead.
question. Nowadays, let's assume you have two independent companies that are independently doing the same thing, and there's nothing nefarious going on. There are ones on one
Right.
side of the country, the others on the other side of the country, both developing their own, advanced car battery. Okay, because everybody knows we need better batteries for cars. Okay, so they both have discovered the same chemistry and the same physics of their new battery. It's the same thing, but they don't know about each other. They both file patents at the US Patent and Trademark Office on their new battery. It's the same battery. Who gets the patent? These guys filed in January. These guys filed their patent in April. These guys win. They were the first to file. So it's a new thing. Even if these guys invented first, they found the chemistry independently in last year. These guys found it this year, but these guys filed first, they still win. The old days of the first to invent gets the patent are gone. That was changed by statute. Okay. So what we recommend nowadays among high-tech companies in fastly evolving fields, file first, file often. So there's a whole process, and everybody's heard of a provisional patent application, which is a very dangerous thing to rely on if you don't know what you're doing with that. We often are filing very regularly as a software product or other product is developing. So we're filing. Then we wrap them all up in a formal application. So that's one way we address that issue.
Okay, that makes a lot of sense. And I see a lot of technology, so I see these things kind of emerge, and there's so many similar companies that exist, and I've always wondered, like, how do we keep how do you protect yourself in that kind of environment? So that makes a lot of sense, especially as we move into virtual spaces and things. Products become similar.
That's another hour-long topic.
Right.
Clients, should we be using Google Docs? Well, I don't know. Have you read the user agreement you click through to use Google Docs for your high-tech company?
Right.
We don't use Google Docs. So, because Google gets to paw through your data for quote unquote analytics. So, they would know, oh, out of the 8 million software companies that use Google Docs, we've noticed an uptick in the number that are using this particular kind of algorithm. That to them would be an analytic. To you, it might be, wait a minute. So,
Yeah.
how do they know? Because they saw in your proprietary internal paper from one person to another saying we should be using this algorithm, not that algorithm. It performs better. I mean, it's really weird. I don't know. So that's an example. That's a whole nother thing.
Yeah, that's a whole nother conversation.
That's a whole
Um,
nother conversation.
Absolutely. Well, I hope that we get to have more of these conversations in the future. It's been super enjoyable. We have a couple of other questions that have come in,
Sure.
but I want to be cognizant of time. So before we get to them, Ted, do you have a couple of minutes to go over, or do we need to
I
wrap
can
up?
be running. My next call's at 2, so
Oh, perfect.
I'm good for a while.
All
Uh,
right. We'll ask the next question and then wrap up. So Todd asked a very detailed question about patent versus trade secret. And let's see, it says, we initially considered patenting our methodology and algorithms that underlie our applications. I read a paper from Yale Law School that suggested keeping these elements as trade secrets may be preferable, as we may not want to disclose this much detail about our secret sauce in the
well,
in the
that's
filing. Sorry.
that's interesting. So reading papers from Yale Law School, Yale Law School's that's the source of the Federalist Society that gave you the Supreme Court that you have right now, by the way. So, as a Yale graduate, I'm embarrassed that Yale Law School is the source of the Federalist Society. Oh, there he goes, comments that, social media. Anyway,
Yeah, we talked about this, Ted. We talked about
yeah,
this.
so reading a paper from Yale Law School. Well, the thing about law school papers is they make, the purpose of writing a paper at law school is to try and make a big splash, and it may not have a lot. It may have lots of ins and outs that are being missed that practitioners see that the academic may not. So you have to be careful about what it says in a Yale Law School paper or any law school paper, even law school papers that I've published or authored and published. So the whether to do trade secret or patent depends a lot on the business model and the technology. And so to give you one example, say you have a technology that if somebody saw what you were doing with your product, without having any access to the actual code, they saw what you were doing, it would be easy for them to copy the process. Well, trade secret's not going to buy you anything at that point because they don't need access to your code. They're just going to imitate it. And if you have no patents, too bad, so sad. So that's an example where you prefer a patent over the trade secret. The other aspect is which aspects of the code are really the trade secret, and do we have a duty under current patent law to disclose those specific aspects in order to meet the enablement and disclosure requirement under patent law? And that's where you need a good patent attorney, because it may be that there's certain details that don't necessarily need to be disclosed in such detail that you lose trade secret status on that specific detail when the patent publishes. The third thing is, are you filing the patent around the world, internationally, or just in the United States? Because it's possible then to have your patent application, if you're only going to be seeking patent protection in the United States, for the application to be kept secret until the patent issues. If the patent never issues, the application never publishes. If the patent does issue, yes, you lose that trade secret status, but you've got the patent. So there are a number of things that need to be considered. And I understand that, somebody wrote an academic paper that, well, trade secrets are better than patents, but I would say it's not in every case. So it really depends on the specific thing. And that's, again, it goes back to having a dialogue with your IP attorney as you're developing your business model and what it is you're doing to sort of sort through, how do you want to play that? It depends on your specific product.
Yeah, absolutely. That's a great answer. And always great insight, Ted. We're going to go ahead and wrap up. And before we do, one of the last questions I want to ask you is, what are some of the most exciting technologies that the technologies that you're excited about right now in the industry?
I'd say the ones that we're most excited about that we're working with probably are related to various applications of neural networks to healthcare. We're doing a lot of that these days. And I think that, I think it's really interesting how that's developed. And the reason why it's exciting to me personally is because in the 1980s, when I was more deeply involved in computer science itself, at the time, they were using this computer language called Lisp to develop what they call production systems or expert systems. And one of the earliest ones that they experimented with was an expert system for doing disease diagnosis. And so it's really interesting to me to see that while that particular experiment got a lot of buzz, and I guess it sort of failed because it never really turned into a widely used product of any kind. But it was considered a great example of expert systems as a way of encoding knowledge representation in a machine. It's fascinating now to see you spin forward 30 years and those ideas have evolved where, Marvin Minsky said you couldn't really do neural networks because, and had various things, but in the end, he's proved wrong. Why? Because the neural network, the technology, the actual ability of the computer system to create that many simulated neurons, and I'm using these terms very loosely, obviously, to generate this knowledge representation out of data, ground truth data, to produce real results that are useful. To me, it's amazing. Obviously, it's potentially dangerous. We go down to have that hour-long conversation. But at the same time, the potential for beneficial healthcare uses is amazing. And I think that's, really, really exciting to us that we're working with that kind of stuff.
Well, I'm going to stop and wrap up the conversation there. Again, thank you so much, Ted, for joining me in this journey. And again, very enlightening, a lot of amazing insight. Why don't you tell the audience where they can connect with you or how they can connect with you, and then we'll go ahead and sign off there.
Okay. Well, great, everybody. Thanks for joining. You can go to our website, www.sabety.net, sabety.net. And we have contact information there, phone numbers. There's a video there about pitfalls with more detail. You can feel free to email me at ted@sabety.net. Don't do .com, that goes to my sister. So sabety.net, ted@sabety.net. So, because you've been on the phone call, I'll give out my email address to y'all. If you want to talk to us, or if you have further questions, that's the best way to do it. You can sign up for a newsletter. If you go to the website, there's a sign up thing, and you got a newsletter, and so we keep people up to date. And so there's phone numbers there as well. So that's the best way to get in touch with us, I think.
Awesome. And you can always reach out to me at andy@nitech.org if you want to get connected to TED or any of our amazing partners. Again, thank you to everyone for joining the conversation, and we'll see you next time. We hope you have a great day.
Thank you. Bye-bye, everybody. Thank you, Andy.